Talk Shoes. Recorded live.
Welcome, everybody. This is Matthew, and you are on our weekly call tonight. This is NTT, New Trust Technology, which is making payments under trust, which is merging titles and extinguishing debts. Welcome to the call, everyone. Our special guest is Christian Walters. And before we get started, I'm going to read the notice of acknowledgement and agreement. This show and or document is private and not to be construed or relied upon as being legal advice for an individual legal situation or or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show and or using the documents herein, you understand and agree that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and is not given legal advice, accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client to Christian Walters. These documents and assured recordings are incomplete and void without this notice of agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, I would like to introduce Christian. Christian, if you can hear me, you are a go.
All right, thanks, Matt.
You're welcome. Welcome to the call.
All right, we're on page, again, 611 at the bottom, and the title section is Section 2, the power of trustees to sign discharges for the purchase money, on page 611. The power of trustees to sign discharges for the purchase money resolves itself into two questions. First, are the trustees justified in making the sale at all? And secondly, supposing the sale itself to be proper, is the purchase bound to see the application of his purchase money? First, are the trustees justified in proceeding to a sale? Number one, trustee for sale for payment of debts. If a testator devise an estate to a trustee and direct a sale for it for payment of debts on the insufficiency of the personal assets, the trustee ought not to dispose of the realty until it appears that the personal fund is not equal to meet the demands of the creditors. But the point we have here is to consider is, how will the purchaser be affected? And as he has no means of investigating the accounts, he is not to be prejudiced should it prove eventually that the personality is sufficient. All it could reasonably, and which happens would be required of him, is that he should apply to the executor, well, the trustees does not sustain that character, and ask if the necessity for the sale has arisen. However, a purchaser is prevented in such a case from dealing exclusively with the trustee out of court, where a suit has been instituted for the administration of the estate, and the court itself cannot make a good title where it has been found in the suit that all debts have been paid. Number two, power of sale on insufficiency of personal estate. But if the testator give not the estate, but a power of sale only to his trustees, and that conditional on the insufficiency of the personal estate, then the purchaser must, at his peril, ascertain that the power can be exercised. The difference between the trust and the power is this. And in the former case, the trustee having the legal estate can transfer to its purchaser by their ownership, and equity, as the purchaser, has no opportunity of discovering the true state of things and will not allow his title to be impeached. But where there is power merely, the insufficiency of a personal estate is conditioned precedent, and if it not be pre-exist, in fact, the power never arose and the purchaser took nothing by the assumed execution of it. Number three, case of selling more than the trust requires. The purchaser is not bound to ascertain whether more is offered for sale than is sufficient to answer the purpose of a trust. For how is the purchaser to know that what the exact sum is wanted? without investigating the accounts. And if the sale by auctioneer, the trustees cannot tell a priori that the property will fetch. Besides, the trustees are entitled, as incident to their office, to raise their costs and expenses. Number 4, Pierce versus Scott case, where a testator directed on the insufficiency of his personal estate a sale in the first instance of estate A, and should that not answer the purpose then of estate B, and the trustee, 15 years after the testator's death, contracted for sale of B first, and then filed a bill for specific performance alleging the existence of debts in that A was already in mortgage or was otherwise charged to full value, the court, considering it was unlikely that the creditors would have lain by for so many years that the non-existence of debts might therefore be suspected, and that it was ground for suspicion might be deemed notice to a purchaser determined against the title. Secondly, supposing the sale to be proper, is the purchaser bound to see that the application of his purchase money? Lord St. Leonard's Act. We must here advert in limine to some important recent enactments by Lord St. Leonard's Acts 22 and 23, Victoria, sections 35, subsection 23, passed the 13th of August, 1859. It is declared that the bona fide payment and to the receipt of any person to whom any purchase or mortgage money shall be payable upon any express or implied trust shall effectually discharge the person paying the same from seeing to the application or being answerable for the misapplication thereof, unless the contrary shall be expressly declared in the instrument creating the trust or security. It will be observed, 1, that the Act applies not to all money subject to a trust, but only to monies arising from sales and mortgages and subject to the trust, and 2, that the language of the section, more particularly of the latter part of it, is in the future tense, so that the enactment is not to be retrospective. If the future settlers are to have option of excluding the operations of the Act, it should not affect prior settlers who have no such option. Number 3, as regards trusts or mortgages created by instruments since the date of the Act, it would seem that to the extent of sale monies and mortgage monies, the whole doctrine of equity of seeing to the application of money has been swept away. It cannot be said where A is trustee for B, the money is payable to B and not to A, and that therefore the clause shall not apply. For the doctrine of equity is that the money is payable to A, but the purchaser of mortgagee is bound to see it properly applied by A. Lord Cransworth Acts next. By Lords Cransworth Acts 23 and 24, Victoria, sections 145, subsections 23, passed the 28th of August, 1860, it was enacted that the receipts in writing of any trustee or trustee from any monies payable to them or him by reason or an exercise of any trusts or powers should be good discharges. But by Section 34, the operation of the Act was expressly confined to instruments executed after the passing of the Act. Next, 44 and 45, Victoria, sections 41. By the Conveyancing and Law of Property Act, 1881, which repealed the 29th section of Lord Cransworth Act, the receipts in writing of any trustees or trustees for any money, securities, or other personal property or effects payable, transferable, or deliverable to them, or to him under any trust or power, are made sufficient discharges, and the section applies to trusts created either before or after the commencement of the Act. As the clause in the acts prior to the Conveyancing of Law of Property Act, 1881, were not retrospective, and questions still arise on titles as to the validity of the receipts by trustees who had no express powers of signing receipts, it is necessary to consider generally and apart from legislative enactment the powers of trustees for sale to sign receipts. Number 1, principle of requiring purchaser to see to the application of his purchase money. As a general rule, if a person having in his hands money or other property to which another person is entitled, he cannot discharge himself from liability but by payment or transfer to the true owner. If an estate be vested in A upon trust to sell and divide the proceeds between B and C, in a court of law, the absolute ownership is in A, and his receipt therefore, will discharge the purchaser. But in equity, B and C, the Seti Key Trust, are the true proprietors, and A is merely the instrument for the execution of the settler's purpose, and the receipt, therefore, to be effectual, must be signed by B and C. 2. The rule controlled by the intention of the settler, such as the prima facie rule in trust, but in every instance it is liable to be controlled and defeated by the intention to the contrary collected from the instrument creating the trust, whether the intention be expressed or implied. 3. Either expressed. The former in this is the case if the settler direct and express terms that the receipts of A, the trustee, shall discharge the purchaser from seeing through the application of the purchase money. For B and C cannot at the same moment claim under the contradictory instrument. They cannot avail themselves of the sale and reject the proviso affecting the receipt. The words in a power of attorney to sign discharges in the name of the assigner or otherwise, and to do all other acts as the principal might have done, have been held to carry such a direction were not controlled by the subsequent receipt clause tending to negative that intent. But the receipt clause has not always been liberally construed, as where the trustees were entitled to receive a sum of stock with a power of varying securities, the receipt signed for cash was held to be no discharge, though the court said there had been any indications to the intention of exercise of the power of varying securities for which the cash would be required. The decision might have been different. It would have been more satisfactory had the court held that the trust fund in the hands of the trustee in the shape of cash did not necessarily imply a breach of trust. The receipt was sufficient. 4. Or implied. In what cases a power of signing receipts is implied has never been satisfactorily ascertained. However, 2 principles appear to be the basis upon most of the distinctions taken by the court have been founded. 5. Direction to sell implies power in sum 1 to sign discharge at the time of sale. First, in the section of a trust for immediate sale is implied that the legal and equitable discharge of the purchase money shall be signed by one at a time of the sale. There can be no conveyance of the estate without payment of money, and there can be no such payment without a complete discharge. Should the settler have contemplated a sale at a time when, as he might have known, the Seti Key Trust or some of them were either not in existence or not of a capacity to execute the legal acts, the intention must be presumed that the receipts of the trustees should be released to the purchaser. Next case, Balfour versus Welland. Thus, where a deed was executed in India for payment of debts with proviso that the creditors in India should be allowed 6 months to come in and those in Europe 18 months, and if any were under disability, they should be further allowed to take the like periods from the time the disability ceased. Sir W. Grant said, the deed very clearly confers an immediate power of sale to the purpose that cannot be immediately defined. It is impossible to contend that the trustees might not have sold the whole property at any time they thought fit after the execution of the deed, and yet could not be ascertained until the end of the 18th month who were the persons among whom the purchase of the sale was to be distributed. If the sale might take place at a time when the distribution could not possibly be made, it must be intended that the trustees should of themselves have been able to give a discharge for the produce, for the money could not be paid to any person than the trustees. Case of infancy. So where heir A divides certain lands to his children, some of whom were infants, the same could be sold with the executors and trustees of his will should see proper, and the purchase money to be equally and severally divided amongst his above-named children. Sir J. Leach said, it is plain the testators intended that the trustees should have an immediate power of sale. Some of the children were infants and not capable of signing receipts. I must therefore infer that the testator meant to give the trustees the power to sign receipts, being the authority necessary for the execution of his declared purpose. Next, as to the Seti Key Trust out of the jurisdiction. As to the Seti Key Trust who, after the date of the instrument, go out of the jurisdiction or are otherwise incapacitated to concur, the general rule does not apply, for it cannot be said that the settlor meant the trustee to sign receipts for them, the presumption being the other way. Number 6, where trust is annexed to the purchased money, it is implied that the trustee shall apply it. Secondly, if a sale be directed, the proceeds are not simply to be paid over to the certain parties, but were a special trust annexed, the inference is that the settlor meant to confide the execution of the trust in the hands of the trustee and not of the purchaser, and the trustee therefore can sign a receipt. Next, Mr. Booth's opinion. An opinion of Mr. Booth shows that even his time regard was held at the nature of the trust in exempting the purchaser from liability. A testator had directed his trustees to sell and invest the proceeds upon the trust thereinafter mentioned, and then gave his wife an annuity of £550 a year for her life to be paid out of the proceeds, and subject thereto gave the fund to his son, but in the case of his death under 21 to the person entitled to his Taunton lands. Mr. Booth wrote, "I'm of opinion that all will be incumbent on the purchaser to see done will be to see that the trustees invest the purchased money in their names in some of the public stocks or funds or on government securities, and in such case the purchaser will not be answerable for any misapplication after such investment of the money, of any monies which may arise out of the dividends or interest or by any disposition of such funds, stocks, or securities. It may not be possible that the testator should expect from any purchaser any further degree of care or circumspection than during the time that the transaction for the purchase was carrying on, and therefore the testator must be supposed to be placed his sole confidence in the trustee." And this is said the settled practice in the cases, and I have often advised so much and no more to be done. And in this opinion, Mr. Waldron also concurred. 7. Trust to pay debts. To the principle under consideration is referable the well-known rule that a purchaser is not bound to see to the application of his money where the trust is for payment of debts generally, for to ascertain who are the creditors and what is the amount of their respective claims is a matter of trust involving long and intricate accounts and requiring the production of vouchers which the purchaser would have no right to require, and a mere absence of statement for the purpose for which the money is wanted will not be a purchaser or mortgagee liable on the ground of presumed knowledge that the money was to be applied otherwise for a payment of debts. So if the trust for the payment of a particular debt named and of a testator's other debts, so if the trust be for payment of debts and legacies, the purchaser is equally protected, for as the discharge of the debts must precede that of the legacies, and the purchaser is not called upon to mix himself up with the settlement of the debts, and he is necessarily absolved from all liabilities in respect of the legacies. Number 8, scheduled debts or legacies. If the trust be for the payment of particular or scheduled debts only, or for legacies only, then as there is no trust to be executed requiring time or discretion, but the purchase money is simply to be distributed among certain parties, there is no reason why the purchaser should not, under the general rule, be expected to see that the purchased money finds its way into the proper channel. Next, Late Assets Act. And the purchaser, where legacies only are charged, is still bound to see that the applications of his money by 3rd and 4th W4, Section 104, the real estate of all persons deceased since the 29th of August, 1833, is liable in the hands of the heir or divisee to the payments of debts generally, whether by speciality or simple contract. Number 9, where notwithstanding a charge of debts, the purchaser must see to the application of his money. And even where the estate is subject by the testator to the trust or payments of debts generally, the purchaser will not be indemnified by the receipt of the trustee if there be any collusion between them, or if the purchaser have noticed from the intrinsic evidence of the transaction that the purchased money is intended to be misapplied, or if a suit has been instituted which takes the administration of the estate out of the hands of the trustee, and these doctrines, it is conceived, are not affected by the clauses of Lord St. Leonard's and Lord Cransworth Acts and the late Conveyancing Act, which apply only to bona fide payments. 10. Purchase from trustee after length of time. And if the purchaser is dealing with trustees at a great distance of time, and when the trust ought long since have been executed, the purchaser is bound to inquire to satisfy himself to the fair and reasonable extent that the trustees are acting in the discharge of their duty, but where 27 years have elapsed and the beneficiary subject to the charge have been led into possession, and the purchaser asks if there was any debts and the vendors declined to answer, it is held that the vendors could make a good title, and Lord Romilly observed that he had known so many cases where after distribution of the assets, the debts had appeared which did not exist at the death of the testator, but which arose subsequently out of the obligations entered into by him, that a very liberal term ought to have been allowed for the exercise of the power of sale. The Court of Appeal has, however, recently expressed an opinion that 27 years is too long a period, and laid down a rule that for the period of 27 years from the testator's death, the purchaser should not be bound or entitled to ascertain whether the debts were paid, but after the lapse of a period that is fair to presume that the debts have been paid, that the purchaser is bound to inquire, and the rule has been followed in Ireland. Number 11, power of signing receipts and question of intention at date of the instrument. As an exemption of the purchaser from seeing to the application of the purchase money depends in a general rule upon the settler's intention, the question must be viewed with reference to the date of the instrument, and not as affected by circumstances which have been subsequently transpired. Thus, if a trust be created for payments of debts and legacies, and the trustees, after full payment of the debts, contract for the sale of the estate, the purchaser will not, upon this principle, be bound to see the application of the money in payment of the legacies. 12. Forbes versus Peacock. In Forbes versus Peacock, the testator directed his debts to be paid and gave his estate to his wife, who he appointed as executrix for life subject to his debts and certain legacies, and empowered her to sell the estate in her lifetime, and directed that if it were not sold in her lifetime, that should be sold at her death, and the proceeds applied in a manner showing that were intended to pass through the hands of the executors, and the testator requested certain persons to act as executors and trustees with his wife. The widow lived 25 years, and after her death, the surviving executor contracted for the sale of the estate. The Vice Chancellor of England held that after so long a lapse of time from the testator's death, the purchaser might have had a risk to ask if the debts had been paid, and if he received no answer, it amounted to notice that they had been paid, and must see to the application of his purchase money. The V.C. observed, when the objection is made by the purchaser that the executors cannot make a good title because all the debts have been paid, if the question is put by him simply, are there any debts remaining unpaid, he has a right to an answer. And on a subsequent day, he observed, here the purchaser has asked the executor whether any of the testator's debts were unpaid at the time of the contract, and the executor refused to give him an answer. Under these circumstances, if it should be turned out that the debts were paid, I should hold that the purchaser had notice of that fact, and that he was bound to see that his purchase money was properly applied. It is evidence that the doctrine was not in accordance with the former decisions, and the cause was carried upon appeal to Lord Chancellor. When the decision below was reversed, Lord Lyndhurst said, if the purchaser had noticed that the vendor intended to commit a breach of trust and was selling the estate for that purpose, he would, by purchasing under the circumstances, be concurring that the breach of trust and thereby become responsible. But assuming the facts relied upon in this case amount to a notice and the debts had been paid, yet the executor had authority to sell not only for the payment of debts but also for the purpose of distributing among the residuary legatees, this would not afford any inference that the executor was committing a breach of trust in selling the estate, or that he was not performing what his duty required. The case then comes to this. If authority is given to sell for the payment of debts and legacies, and the purchaser knows the debts are paid, is he bound to see the application of the purchase money? And apprehend not. I apprehend not. Lord St. Leonard's, with reference to the same important case, observed, when a testator by his will charges his debts and legacies, he shows he means to trustees that the powers of receiving the money anticipating that they will be debts and thus providing for the payment of them. It is by implication and declaration by the testator that he intends to entrust the trustees with the receipt and application of the money and not to throw any obligation upon the purchaser or mortgagee. That intention does not cease because there are no debts. If a trust be created for payments of debts and legacies, the purchaser or mortgagee should, in no case, and in the absence of fraud, be bound to see to the application of the money raised. And his lordship added, as to Forbes versus Peacock, it is quite a mistake to suppose that it was a trust executed at a distance of 25 years from the time when it arose, for it was executed at the time when it had arisen, which happened to be 25 years after the death of the testator. Number 13, power of varying securities and of investment. If a trustee having authority to invest a trust fund with a power of varying securities, but without an express power of signing receipts, it is implied from the nature of the trust that he shall sign receipts, and if he be authorized to invest on securities simply without power of varying securities, he can sign receipts, and for he cannot prevent the borrower from paying off the money, and who the trustee can receive it back. Indeed, a power of investment has been held to carry the power of varying securities, where, however, the trustee is directed to invest upon security, but real security is not mentioned, and he lent upon a mortgage. The court did not think so clear that the trustee could sign a receipt when the money was paid off as to compel the purchaser to take title, which depended on the question. The power of signing a receipt in such cases turns on the intention as collected from the instrument, and unless it continued authority to lend on the mortgage, no power of signing a receipt when the mortgage money is paid off is implied. 14. Power of sale and exchange. A power of signing receipt is held not to be implied in the power of sale and exchange, but in the case it was a mere power of sale and exchange and not the ordinary power inserted in settlements, accompanied with directions for laying out on another purchase with interim investment on securities. 15. Charge of debts. The case in which the testator, instead of devising the estate upon an express trust for payment of debts, creates a charge of debts upon his real estate, seems to require particular examination. It might be seen a simple and useful rule to hold under such circumstances that the executor, and the executor only, as the person who has administration of the personal assets, should, by virtue of an implied power, sell the real estate for payment of debts, but no such rule ever existed, and we proceed, therefore, to ascertain as far as can be by what principle the court is guided. A. Devise to trustees with charge of debts. If the testator charged his real estate with debts, and then devises to trustee upon certain trusts which do not provide for a sale or perhaps even negative the intention of conferring a power of sale, can the trustee give good title to the purchaser? It is clear and the subject to the restrictions arising under the Settled Land Act, which will be subsequently discussed. The trustees and the executor together can sell, and the question is what principle this proceeds. Is the executor the vendor? And if so, has he legal power which enables him to pass the estate at law independently of the trustee? V.C. late L.J. Knight Bruce seemed in one occasion to think in the case of Shaw versus Borer and Ball versus Harris might have been decided on this footing, and some recent cases lean in the same direction. But the notion of the executor passing the legal estate in such a case was never suggested until the last few years, and has been said by the Court of Executure in Doe versus Hughes was at least true at the time it was spoken, is that not a single case should be produced in which a mere change had been held to give the executors a legal power. Have the executors then an equitable power, and is the trustees who has the legal estate bound to convey it as an executor directs? This doctrine should be a very rational one, but there is no trace of it in the cases themselves. Apparently they were decided on the familiar principle that the court of equity were no difference between the charge of debts and the trust for payment of debts, and that the trustees therefore took the legal estate upon the trust of the will, the first of which was to pay testator's debts, it is certainly not a little remarkable that after the examination of all authorities upon the subject, there does not appear to be one in which the trustees has sold alone, without the concurrence of the executor. This circumstance may be easily accounted for, as trustees of the will are also invariably apportioned executors also, and where it is not the case, the purchaser naturally requires the concurrence of the executor, not on the ground that he is the vendor, but to satisfy the purchaser that the sale of the real estate is bona fide from the insufficiency of the personal asset. In some of the cases, the court noticed, but not laid any stress upon, the circumstance of the personal representative concurring, or the character of trustee or personal representative being combined. But in others, the facts have been passed over in the silence as a mere accident, and the court has relied on the general doctrine that trustees of the estate charged with the debts could sell and sign a valid discharge for the purchase money. In Doe versus Hughes, the case most adverse to the powers arising from the charge of debts, it was admitted by the two trustees of the real estate, subject to the charge of debts, the trustees had thereby imposed upon them the duty of raising the money to pay the debts, and thus was the option of Lord Hardwicke, or the opinion of Lord Hardwicke, as expressed in a case which do not remember to have been cited in Ex parte Turner, where the estate has been given subject to debts, but no express trust was created for the purpose. He observed, where a divisee is general in trust or subject to pay debts, the divisee may sell or mortgage, but he may pay money to the creditors of his divisor, but he do not, and the mortgagee is not to suffer. For the case of the general divisee, he is not obliged to see the application of the money he advances. But even in this case, the inconveniences often arise for where the estate is equitable assets as to where it is accompanied with a trust. The creditors who have not specified specific liens upon land ought to come in equity and a pari passu. However, if the trustees prefer one creditor to another where he ought not, the remedy usually is against the trustee and not the lender of the money, for the latter was to see the application of his money upon so general a trust, he could not safely advance his money without a decree in this court. If the trustees of the estate charged with debts can, by the virtue not of the express trust but of the trust implied by the charge, sell the estate and sign the receipt for the purchase money, it would seem to follow that they cannot allow the proceeds to be paid to the executor as not being the proper hand to receive, the executor in the character having no privity with the real estate. The necessity of requiring the concurrence of the personal representative would often lead to practical inconvenience, for on the death of the executor intestate, there should be no personal representative of the testator, and the personal assets having been exhausted, there would have been no fund or taking out of letters of administration, not to mention that should the executor be held to have any concern with the proceeds in the real estate by virtue of the will, the administrator, not being appointed by the will, would not succeed to the power of the executor, which should be borne in mind as of some importance to considering whether the sale is subsequently that of the executor or the trustee who takes subject to the charge. Should the neat point ever call for decision, it will probably be held that the trustee, without concurrence of the executor, can give good title. Lord St. Leonard's Act. By Lord St. Leonard's Act 22 and 23 Victoria, sections 35, subsection 14, whereby will coming into operation after the 13th of August, 1859, a testator charges real estate with payments of debts or any specific legacy or sum, divises an estate, so charge the trustees for the whole of his estate or interest, and makes no express provisions for raising the debts, legacy of the sum, the divisees in trust may sell or mortgage. And by Section 15, the power is continued to all persons taking the estate so charged by survivorship, dissent or devise, and by Section 17, purchases with mortgages are not bound to inquire whether such powers have been duly or correctly exercised by the person or persons acting in virtue thereof. Where the debts are charged, of course, purchaser or mortgagee under these powers is not bound to see to the applications of his money, and where a specific legacy or sum is charged, if the amount enactments do not per se confer a power of signing receipts, the purchaser or mortgagee is exempted from seeing to the application by the 23rd section of the same Act. The 18th section declares that the Act shall not extend to the to a devise that any person or persons in fee or entail for the testator's whole estate and interest charged with debts or legacies, not shall it affect the power of any such devisee or devisees to sell or mortgage as he or they by law now do. To make this section consistent with the 14th, the devise referred to in the 18th section must mean a beneficial devise, and devisee or devisees a beneficial devisee or devisees, and the inference would seem to be that, in the view of the framer of the Act, no legislative assistance was needed in the case of the beneficial devise subject to the charge. Indeed, the concluding words of the section seem almost tantamount to declaration of legislature that beneficial devisees subject to the charge have power to sell or mortgage, which the case we next proceed to consider. Next, devisee to personal beneficially with charge of debts. If a testator charged his debts and devised the estate subject to a charge to A, and his heirs not upon trust for his own use, can the beneficiary in this case make good title? The answer to the questions last discussed is an answer also to this. For if where the express trust negatives the intention of the conferring of a power to sell, the trustee can still take good title, it is evident that he can only do so by virtue of the charge. Any distinction between the two cases wouldn't be in favor of the beneficial devisee, for if the trustee, in defiance of the express trust, can sell a fortiori, the devisee can, who is fettered by no such restriction. In both instances, the charge operates as a trust for payment of debts and is attended with all the same consequences. A charge, said Lord Eldon, is in the substance and effect pro tanto a devise of the estate upon trust to pay debts, and this, observes Lord St. Leonard's, on citing the dictum, is supported by the current authorities. It is clear that the devisees can, where he also fills the character of executor, make a good title, and in some cases the court did not seem to rely on the characters being combined, but it is singular that no authority can be found in which the question whether the devisee alone can make good title has arisen. In the Court of Executure, it was said that the devise to trustees subject to charge of debts, the trustees could sell, but the charge in the hands of a devisee if the lands were devised, or in the hands of an heir at law if the lands descended, was a charge only in equity. The court was there considering, more particularly, the question of legal powers, but it was intended to be said that the devisee subject to a charge could not sell and sign a receipt for the money. The doctrine is inconsistent with the nature of the charge of debts in equity as commonly understood. The prevalent opinion here thereto is believed to have been that the devisee subject to the debts can sign a receipt for the purchase money, and if cases in which the court has upheld purchasers from a devisee with the concurrence of the executor, but without relying upon such concurrence, would be a trap for purchasers, should the court now refuse to uphold the purchase from the devisee only. Considering the declaratory words contained in the end of the 18th section of Lord St. Leonard's Act, it is conceived be safely assumed that the purchaser of the devisee subject to the charge of debts will, without concurrence of the executor, acquire good title. Next, charge of debts where there is no devise of estate. If a testator charges his debts to the real estate and does not devise the estate at all, but allows it to descend to the heirs, can the heir sell and sign a receipt for the purchase money? It appears to be clear that he cannot, for he takes nothing under the will and cannot therefore be regarded as a person constituted by the testators and trustee by implication for payment of debts. He can pass the legal estate, but he could not sign the receipt. That is, if the heir misapplied the money, the creditors might still come upon the estate. But in this case, if the heir is disabled from selling, can the executor sell? That is independently of the Lord St. Leonard's Act, to be mentioned presently, for otherwise the charge of debts amounts to the discretion for a chancery suit. The legal question arose in Doe v. Hughes before the Court of Executure that the court held that a charge had no operation at law but must be enforced in equity. This decision has been found much fault with. The Master of the Rolls said that before the case in executure he had considered the law and had been in charge of debts gave the executors an implied power of sale, for otherwise it was argued in the case of a charge where the estate descends, there can be no sale without the aid of the court. But this does not appear to follow. If a testator expressly direct that his estate shall be sold without naming the person and the funds to be distributed in a way in which the executors alone can distribute it, the power of sale is given to the executor by implication over the legal estate, even in courts of law. By analogy to this, there have been no direction to sell, but only a charge of debts. This last, though an umbra in a court of law, creates an equitable power of sale or mortgage in a view of the court of equity, that is, the executor may contract for sale and the acceptance of the title by the purchaser. The person in whom the legal estate is vested will, as being a trustee for the executor, be compellable to convey the executor directs, and if he refuses, the legal estate will be vested in the purchaser by aid of the Trustees Act. In Goslings v. Carter, Vice Chancellor Knight Bruce declared to have the opinion whether the mere discharge or the mere charge of debts gave to the executors a power of sale either at law or in equity, but would not compel a purchaser to take the title from the executor without a concurrence of the heir at law. In Robinson v. Lowater, the legal estate was already in the purchaser, so that the legal question did not arise, but it was held that the executors had given the purchaser a good title. In Edisforth v. Armstead, the Vice Chancellor Wood confessed to follow Robinson v. Lowater and held that the power of sale to be, according to the report, in the trustees, but which appears to be a mistake for the executors. The surviving trustee has devised to the trust estate, and the devisees therefore could not sell, but the surviving trustee was also surviving executor, and appointing the devisee his executor, and in the character of the executor, the devisee might be thought to be represented the original testator, though it seems the better opinion that even then the power of sale would not pass to him. In Wrigley v. Sykes, the Master of the Rolls decided that the executors could not contract the sale of the estate, but guarded himself to say that the court, as far as it could, would certainly secure the purchaser a good title, a good legal estate when the conveyance was made. It is conceived that Doe v. Hughes was perfectly sound discretion upon the legal question, but that the executors have an equitable power of sale, and consequently the holder of the legal estate is trustee for them. This power of sale is implied because the executors are appointed by the testator to pay his debts, but such a power has never been implied in the administrator, who is not appointed by the testator, but is the officer of probate court. Next, Lord St. Leonard's Act. By the Lord St. Leonard's Act 22 and 23 Victoria, sections 35, subsection 16, as to wills taking effect since the 13th of August, 1859, where a testator charges his debts or any legacies upon specific sum and has not devised the estate to trustee or trustees, the executor for the time being may sell or mortgage, and by the 23rd section, the purchaser and mortgagee is not bound to see to the application of the money, it would seem that the executor is thus empowered to pass the legal as well as the equitable estate, for the clause proceeds that any sale or mortgage under the Act shall operate only in the estate and interest, whether legal or equitable, of a testator, and shall not render it unnecessary to get in any outstanding subsisting legal estate. It must not escape notice that the power to sale is confined to the executor and a person whom the testator himself entrusted, and is not extended to the administrator. Next, charge of debts where the estate lapses. Should a testator charge his debts on the real estate and then devise the estate to A and his heirs beneficially, and the divisee dies in the testator's lifetime so that the estate descends, can the heir in this case sell and sign receipt? If the heir cannot sell, where the estate is never devised but left to descend a fortiori, he cannot in this case, for here not only of the heir is not invested with the character of trustee until the will, but the estate, subject to the charge, was devised to another person who was therefore intended to execute the implied trust. The machinery contemplated by the testator failed by act of God, and no alternative remains but that the trust should be executed by the court. And it is presumed that under these circumstances it could not be held that the executors have by the will, even in an equitable power of sale, the divisee, had he lived, would have been the proper person to execute the trust, and the power of sale cannot belong to the executors, as the testator could not be taken to have contemplated his own intestacy in real estate. Next, Lord St. Leonard's Act. However, by Lord St. Leonard's Act 22 and 23, Victoria Sections 35, Sections 16 and 23, as to the wills coming into operation since 13th of August, 1859, the executor may sell or mortgage and sign a receipt for the money. Next, charge of debts where the estate is subject to various limitations. Suppose a testator to charge his debts and to devise an estate to A for life with contingent remainders or other limitations, which render it impossible that the implied power of sale can be executed by the divisees. Thus has occurred in several cases, and the result appears to be that the court, if it can possibly avoid it, will not construe the charge as a direction for the chancery suit, but will assume that the power of sale for payment of the debts has been given to one, and that it was not given to the divisees. It must be intended for the executors. In such a case, the executors must be considered to having an equitable power of sale. In the case of the executor, directly decided that the executors have no power themselves to pass the legal estate, where in the case supposed, the executors take an implied equitable power of sale upon face of the will, it is immaterial whether the devised in estate do not lapse except for the legal estate will, as it happens, be in the divisee or the heir at law. If a conveyance cannot be obtained, recourse must be had to the Trustees Act for the transfer of the legal estate. Lord St. Leonard's Acts. However, Lord St. Leonard's Acts 22 and 23, Victoria Sections 35, appears to apply to such a case. For though the devise is not to a trustee as required by the 14th section, yet in the case where in the 16th section, where the whole estate and interest of the testator has not become vested in a trustee or trustees, it is presumed that the 18th section was meant to accept from the Act's divises to a person or body of persons taking a fee simple or fee tail in presenti fee from executory limitations over, and not devises the fee simple to several persons in succession for particular estates. True principle. The true principle, which, independently of the Act referred to, ought to be governed to these cases would appear to be that where a testator devises the estate to trustees or to a beneficiary the charges of his debts, where the trustees or beneficiary should have a power of sale, and signing receipts, but that where a testator charges his debts and does not devise the estate, or devises it in such a manner that there is no one who can execute the trust, there the executor should have an equitable power of sale and signing receipts, that the depositaries and legal estates should be trustees for them and bound to convey it as they direct, but that where the testator has devised the estate and therefore provided a hand to execute the trust, but the trustees or devisees dies in the testator's lifetime, thereas the hand to execute the trust has only failed to act of God, no person has power of sale or signing receipts, but the trust can only be executed by the court. Might be wise to review that true principle section again. In the middle, going back up again, where it says, but that where a testator charges his debts and does not devise the estate, or devises it in such a manner that there is no one who can execute the trust, the executor should have an equitable power of sale and signing receipts, and that the depositaries of the legal estate should be trustees for them. The depositaries of the legal estate should be trustees for them and bound to convey as they direct. That sounds like that's the county. Repeating again, the executor should have an equitable power of sale and signing receipts, that the depositaries of the legal estate should be trustees for them and bound to convey as they direct, but that where the testator has devised the estate and therefore provided a hand to execute the trust, but the trustees or devisees dies in the testator's lifetime, thereas the hand to execute the trust has only failed by the act of God. No person has power of sale or signing receipts, but the trust can only be executed by the court. That would take some contemplation on that. But anyway, continuing on. 16. Story versus Walsh. It remains to notice in connection with the subject the case of Story versus Walsh, in which Sir J. Romley, M.R., held in substance that the devisee subject to a charge of debts and legacies may, with the concurrence of the executors, declaring all the debts and legacies having been paid, sell for his own private purposes and give the good title to the purchaser. This case resembles that of the executor, who is also specific and residuary legatee, selling a chattel interest for his own private debt. 17. Effect of Settled Land Act. Before quitting this section, however, it will be proper to avert the question whether the power of selling or mortgaging the property which arises under a charge of debts is affected by Section 56 of the Settled Land Act, 1882. That act, after giving large powers to the tenant for life, including the general power of sale, the power of mortgaging for specific purposes, which do not include the payment of encumbrances on the settled property, and providing by the Section 56, subsection 1, that powers given by the settlement of trustees are not to be prejudicially affected by the Act, enacts in subsections 2 that the consent of the tenant for life shall, by virtue of the Act, be necessary to exercise the trustees of the settlement or other persons of any power conferred by the settlement exercisable for any purpose provided for in the Act. And the question is whether this makes the consent of the trustee for life necessary to the exercise by the trustees of the power of selling or mortgaging arising under a charge of debts. Now, in the first place, it seems clear that the only power of mortgaging given by the Acts is of a very limited nature, and for the purposes wholly dissimilar for those for the power under the charge of the debts is exercisable. The trustee's power of mortgaging is unaffected by subsection 2 and may be exercised without the concurrence of the tenant for life. With reference to the power of sale, there would be more difficulty as the tenant for life has general power of selling, and under the Section 21, the proceeds of the sale may be applied in discharging the encumbrances affecting the inheritance of the settled land. Sale of the settled property or part thereof for the purpose of paying off the encumbrances seems, therefore, to be strictly a purpose provided for in the Act, and it is difficult construing the Act fairly to avoid the conclusion that the trustees cannot sell without the consent of the tenant for life. The result of this construction of the Act is without doubt inconvenient, and in the view of the power of sale arising under the charge of debts is unaffected by the 56th section and supported by the weighty opinion, but until that view has received the sanction of the court, a purchaser could not be safely advised to accept title from the trustees without the consent of the tenant for life. Who must sign the receipt? As a trust for sale is a joint office, the receipt may be signed by all the trustees who have undertaken to act, and where power is given to the trustees to discharge the purchaser from seeing to the application of the purchased money, the receipt must be signed even by the trustee who has parted with the estate by conveyance to his co-trustees, for the transfer of the estate at law carries not along with it the confidence in equity. I want to read that again. For the transfer of the estate at law carries not along with it the confidence in equity, but the receipt need not be signed by a trustee who has disclaimed, for by the effect of a disclaimer, the acting trustees are put exactly in the same plight as if renouncing the trustee had never been mentioned. Okay, I think we'll pick up there on number 19, power to sign receipts in one and delegation to another on page 638. We'll bring up that next time on page 638 under 19, power to sign receipts in one and delegation to another. So let's open it up for some questions.
All right, page 638. Okay, folks, here's an opportunity for you to ask Christian a question. If you got a question, go ahead and hit star 8 on your phone, and we'll go ahead and open up the phone lines here and give you an opportunity to talk.
Yeah, I hope everybody's listening to these readings because we're getting into some more meatier stuff that applies more in today's, what's going on today. So don't think that this is such a boring read. Don't fall asleep on the pages because, hey, you're going to be missing something.
Right. So anyone who's got a question, go ahead and hit star 8, and we will unmute you here. Oh, here we go. First caller, go ahead and give us your first name, please.
This is Dave.
Welcome.
Thank you, Matthew. Hi, Christian.
How you doing, Dave?
I'm good, good. Do you have time for a baby question?
Sure.
When you did but hypothetical, in a civil action, when you sent the NOI in, would you send copies or certified to be true and correct copies? Because my understanding was that you keep back all originals. And my question was, would the court view receiving copies as an answer to a petition or a complaint?
Okay, so this is the answer to the original petition?
Yes. So you know why.
Okay, those could be copies.
Yeah. My only concern was that they wouldn't just discard them because there weren't any originals in there.
Doesn't the court require originals when you file them?
It's done through the mail because it's so far away.
Yeah, maybe the court would require an original, but you could probably squeak one by if you had a good enough photocopy of one.
The other option is to have a certified copy. That way you keep your original and just have a notary certify that it's a copy of the original.
Well, if the notary does an affidavit of mailing, do you need to send the original affidavit of mailing then? I guess would be the question. Rather than a copy.
Well, it all whether or not this was a return as a special deposit, and that was actually a payment used as a merger of the titles. If that was, I would definitely original piece.
No, I'm sorry, but
No way around. What am I saying? I'm mixing that up. If it was a payment, I would send the originals.
No, it's not. It's not a notice.
Just a notice?
No. Yeah, it's just a notice of interest.
I would keep the originals then.
Then I would go to prove trust when I go to the hearing. That's the idea.
The special deposit that was the actual res, then I would send them the original. If not, I would keep the original.
Okay. It's not a special deposit until you, well, in other words, it's been noted. I mean, notice has been recorded in the public, in one place. I wouldn't put the other ones in for the witness until I put them in the court case. The purpose of the NOI was just to give an answer within the prescribed time.
That could also be a special deposit if you made it one.
Okay, well, yeah. Now, is UPS? I mean, sometimes it's ideal to send registered mail, but sometimes you just can't. So it seems like UPS would be okay, wouldn't it? That's fine for it. Yes. You don't get a green card back, but maybe I can get the receipt from the UPS.
Does that contain a signature on a receipt there or something?
Whoever receives it at the other end has to sign.
Even with UPS?
Yes. Yeah, anybody that gets a UPS package or envelope had to sign for it.
Well, if I get a signature, I got something positive that was delivered. So prove them that they got it.
Yeah, no, you'll get a confirmation that it was delivered to that address. I'm just hoping that's good enough. As far as meeting the requirements of delivery.
Yeah, we're just creating a record for delivery so I can prove it. That's all.
Well, thank you so much for that answer. I'll get off now and let somebody else ask an intelligent question.
If you would take the original complaint with the answer that you're responding back and incorporated that with it and turned that into a special deposit and just sent that in and then turned the whole case into the trust res instead of just responding.
Well, I was thinking that you turn the whole case into trust res and send it to the party that, the trustee. And then when you went to the hearing in the court, that's when you get into the camera and prove trust with all originals.
Yeah, you could do it any time after that. Could have done it with a response or anything.
Even after a judgment, if they went ahead and rushed to judgment.
Yeah, you could, even after the judgment.
Yeah. Well, that's what I love about NTT.
Okay, anything else?
No, that's all I had. I appreciate your time. Thank you so much. I love the program.
All right. Great question. Thanks for jumping on. Next caller, you've been unmuted. Go ahead and give us your first name, please.
Hello.
Hey there.
Hey, I had a hypothetical I wanted to run past you guys. Let's say there was a criminal case and a search warrant was served and all that, and you were taken in and signed everything that they they brought to you, you signed by grantor, what would be your next move?
Go get certified copies of the original, whatever the charges were and stuff.
Okay.
And turn that into the trust res.
Okay, there still hasn't been any charges filed. There was bail bond for $25,000 was transferred, I guess you would say, and so I signed that also by grantor. So that's I would have to get that back to you, right?
With case number on it?
I'm sorry. One more time.
Is there a document with a case number on it?
The search warrant has a case number on it.
Okay. Anything that would identify the number that they're going by, I would use that as that is the debt title, and then just put your equitable asset on top of it and send it back merged.
Then the search warrant with all that's the UCC process, which I'm going to need to be working on. Another question: is there somebody or some way that I can get with to maybe assist with the whole claiming process?
The NTT, Welcome NTT group?
I'm on the Free American Yahoo group, and I tried to find. I heard you talk because I've been going through the recordings, and I heard you make reference to that, but I tried to Google it for some reason. I couldn't find anything. There was like a Canadian.
It's not on Google. It won't come up on Google. It's on Skype.
On Skype. Okay, yeah, I just got Skype, so I should search for
you
what?
want to Skype Faith to Trust. That's FIITH and the number 2 and Trust, TRUST.
All right, excellent. All right, well, thank you guys very much.
And then once you're into the group, you'll get the more contact with some people that could help you out.
All right, sounds awesome. I'll tell you what, I went ahead and tried calling a couple lawyers just to hear what they had to say, and anything that comes out of all their mouths, it's just negative. It just puts you down, and yeah, what a waste of time that was. But anyway, all right, well, thanks a lot.
All right.
All right. Some good questions. Do we have anybody else out there that has a question tonight? I see a lot of familiar faces, so just fun, guys. If you got a question, hit star 8 on your phone.
Has anybody been reading the Equitable Maxims out of some of those older books and comparing them?
We got somebody who just jumped on. Zyq, did I say that right? You've been unmuted.
Hello, Christian.
Hi.
I'm here from Arkansas.
Hi.
Hey, we went to the law library today, and we were able to go on to the Westlaw digital terminal.
Mm-hmm.
And we downloaded all of the first, second, third restatements of the laws on trust.
Oh, that's great.
So the question I have is, how do we get them to you? Because they're very large files.
Probably Skype will handle it.
Think Skype will be able to handle them?
Yeah. Yeah.
Okay. Well, we will be sending them along post haste. And I guess once you get them, you can put them on the shared so other people can use them.
Yeah, we should start maybe compare the difference between at least the first and the second, how they made some changes, and then the difference between the second and third.
Yeah. Well, it may take a little while to digest them. There's quite a bit of stuff there.
Oh, yeah.
But anyway, that's the only thing I had to report to you. I know you mentioned last week that if somebody could get those, I'd like to get them. So.
Yes, I had the third already, but I didn't have the first and the second. I had like the first 16 sections and the second, but it's not quite good enough. So I thank you I appreciate that.
Well, you're welcome. I suppose those will come along this evening.
Did you get to look at the hard copies that were there?
Yeah, we had looked at the books, the volumes in paper, and I had copied some of them out, or parts of them. But today we just downloaded the digital form from Westlaw.
Did they have any books like Pomeroy on equity proceedings and some of those older ones that were?
Didn't look for those today. We'll probably go back and do some more looking for the older books. There are a lot of books in the law library that are extremely old, mid-19th century and forward. So there's a good chance they will be there.
Mm-hmm.
But no, we didn't look for those today.
Kind of interesting to see those old books. But anyway, most of them you can get online on Google Books, but that would give everybody access to them. All you have to do is Google Book search and pull up those books. And I really suggest that everybody looks at some of those old ones and compare each book, and especially the ones that have the breakdown and explanations of the maxims in equity.
Right.
And then compare each book, say about at least 3 books or maybe 6 books, compare them and put together an equity explanation. We're not talking about a whole bunch of maxims. We're only talking less than, I think, 20 maxims.
Right. Well, I was looking through my stuff on my computer, and I found a folder with maxims of law, and I opened it up because I had forgotten I had it. And it's a whole list of all of these maxims in Latin. There's more than 20 of them.
Right. So there might be confusing them with the common law maxims, so I don't know if the equitable maxims might be mixed up with something else.
Yeah.
I was reading a case last night that there was one of the maxims, I don't remember exactly how it was worded, but it was to the effect that, let's see if I can remember. It was the maxim that kind of led to that equity will not allow impossibilities to be forced. Something to that effect. I forget how that was worded. But then I couldn't see, how could that be, what they might have been talking to. But then last night I ran across a case that was exactly how I could see how that would work.
Mm-hmm.
And how that could be used. It was a case consisting of a trust that was out of Florida here, and the trustees had been appointed or ordered by the court to repatriate the funds that they had transferred overseas. And the way they had the trust all set up was that when they asked, there was another trustee involved that had the right to refuse, and he would refuse, but the court had ordered these people to repatriate the funds. But see, the trustee that they ordered, that was a foreign trustee, had the right to refuse, and when he refused, that left them in the middle, not having any control or power over this trustee, and it was an impossibility that they could force this other trustee to do any kind of duty because he had the right to do that. So the court was putting them into an impossibility. So now with this equitable maxim, you can come in and claim as defense and effectively take the teeth out of the outlaw side contempt by using this equitable maxim because it was creating an impossibility that you couldn't do, and equity would not allow it.
Right.
So I think it's very important because, like I keep saying, the equitable maxims are our shield for defense and our sword for offense. And we need to go back in these older books and compare the meanings, how they explain these maxims, and get a better grasp of what they mean and how to apply them.
Yes. That'd take a great deal of study as far as.
Well, I don't think it's going to take a great deal of study because there's not that many of them.
Right.
Compared to 63 million statutes and codes on the at-law side, comparing to 20 max or so on the equity side, that's nothing in comparison.
This is true. Well, I'm looking at the list of the
maxims we should be able to know like the back of our hand and be able to spew them off and understand them.
Yep.
What were you saying?
I was looking at the list here that I got from Wikipedia, and I don't see the one where it says actor will not allow impossibility. Would that be the equivalent of equity abhors a forfeiture?
Doesn't sound like it.
Yeah. Oh well. We'll do our study on that.
Yeah, that went off Wikipedia that I've been giving everybody. That's, at that time, I don't know how modern that is, or how old that is, let's put it that way.
Uh-huh.
That may be a little more modern, but anyway, that was a good starting point.
Exactly. Pretty good reading.
So anything else?
Well, we checked with the bankruptcy JA today, and she implied that, well, she first of all said she couldn't give legal advice, but she implied that we were going at our strategy perhaps incorrectly as far as getting a evidentiary hearing and that sort of thing. So we are trying to figure out how to get in for the evidentiary hearing so that we can get our counterclaim in.
Mm-hmm. How did she imply to go about it?
Well, her response was that she couldn't give legal advice, so she didn't give much information.
Well, you should have told her, well, this process is not legal advice. That's just rules of court.
Yeah, that's their out, is that they're saying they can't give legal advice.
Yeah, well, you're not asking legal advice. You're asking for court process and procedure.
Yeah.
Really, there's nothing legal about the at-law side, I think.
Yeah. Well, anyway, we're still with the issue of not being able to get the counterclaim brought forth. So we have decided that what we probably should do is go ahead and ask for a continuance on Wednesday and see if we can't work on getting that process done properly.
Mm-hmm.
I
wish I was up more to speed on bankruptcy, but I'm not as much on. Might want to confer with somebody who has more bankruptcy experience to find out about the right process and procedure to get that in there.
Yeah. Well, if there's anybody on the line who's on Skype, perhaps he or she might willingly share that information or give us some thought. That would be appreciated. I did go on the website for the bankruptcy court, but all of the rules and stuff that they had on there were all amended rules. I couldn't find anything on there where it had the rules per se, so didn't have much luck there.
So she seemed to imply that it was doing something wrong, the wrong process?
Yes, but she didn't give any details. as to what we needed to do to correct. So perhaps we'll have to approach it from another angle. We are thinking perhaps that with the adversarial claim that was put in by the trustee, that she may be the key, and it's through the cross-claim or counterclaim of her adversarial claim that might bring everything into equity for us.
And this was the trustee that was saying that?
No, this is kind of our thinking through the trustee. You know, she gave us that adversarial claim that we kind of went over last couple of weeks ago.
Right.
Well, if you probably didn't notice it, but as we read it, it was full of all kinds of blunders, and what they did is they took two motions and put them together and kind of combined the wording and did a lot of stuff that just doesn't make sense as far as why would a lawyer who's supposed to be a good lawyer be making these kind of, what look like mistakes.
Well, if they can get the mistakes rammed through, they would stand as being, what they would get through the court.
Yeah.
That's file objections to, and then be able to back it up with something, some kind of SOI. That they were using the rules improper or something.
I'm not exactly sure what they were doing. You remember we mentioned it.
And again, that's the maxims come in, because if you could learn how to, knock it out with a maxim that was the SOI, the support that they were doing something wrong, the objection, and keep it on the equity side rather than argue the at-law.
Uh-huh. Well, we did the denial, or not denial, but we answered it with certain ones denied and some others rebutted and that sort of thing. But now we're working on the counterclaim, along with the memo in support thereof. All in equity.
I wonder if you could put a stay in there and stay the at-law side, what they were doing, until the equitable counterclaim is heard.
Would that be...
These are at-law side for any kind of actions until the counterclaim is heard.
So that would be a motion, just put in a motion for a stay for the at-law side until the equitable claim is heard?
Yeah.
Okay. We probably could do that.
You said you had an attorney at one time, right?
Yeah.
Is he still on speaking terms that you can go back to him and confer with?
Oh, I'm sure. He talks to us, yeah. He just wanted to make a big show of it and argue and all that stuff. I
wonder if he could be a source of information that you could glean from asking questions, what he thought.
Well, that's a possibility. He might say, well, he's not a part of the case and he no longer wants to be involved.
Yeah, because if you couldn't get your counterclaim in there to present it right, and so you could get it the way they see that it has to be presented in order to get it on the court, so that they'll recognize it, then that would be maybe the issue, to confer with him and see whether or not, if you're doing the right thing.
Right.
Because if you can't get it in there, get it to be where it's seen, then it's...
Well, we're cooked. basically.
Yeah.
At least that's the way we see it, because if we don't get to speak first and claim trust and bring it into equity, then the other guy's gonna maybe all his questions.
Yeah. Well, if anybody's on a call that knows anything about bankruptcy, maybe it could help out in bankruptcy procedures for filing any adversarial counterclaim. If you get a hold of help out here.
Hey, hit star 8 if you want to jump in. I'll unmute you.
Well, it would be appreciated, any assistance. Like you say, this is all cutting-edge technology, so kind of a...
Well, I'm not up on the bankruptcy court rules to tell you if you're doing the right process and procedure right to get it in there.
Yeah. Well, it's interesting that the other motions that we put in, you remember you told us that we need to put in the counterclaim first before you could put in the other motions for example, the motion for strict compliance of equitable principles.
Mm-hmm.
Well, they're going to discuss that one, but there's no mention of discussing the counterclaim.
Well, did you set the hearing or did they set the hearing?
Well, I suppose whoever they is defined as, because the letter came that there would be a hearing on the 27th.
Okay, well, if you didn't set the hearing, then you don't get the chance to put on the plate what you're going to talk about.
Well, that was another thing that we asked today, and there was something wrong with the process or something that we weren't able to request a hearing. And I didn't talk to her. I was beside the window, but I didn't get to hear what she said.
Okay, you need to find out, because if you can't set a hearing properly, then you can't set what you want to be heard.
Right.
And if you want this counterclaim to be heard, then you're the one that's going to have to set it.
Right. Well, it appears as though that the lawyer for the ADF&A is the one that must have set the hearing, because it's all his issues that are being discussed.
Right. But then, if you're going to continue it, make sure you've got good cause shown, or else you won't get your continuance.
Well, whenever he asked for the continuance last time, there was no request for cause. They just judge asked him, or he.
Did you object? Did you object?
No. So went ahead and said that would be fine.
Yeah, because if you don't object, then it's granted.
But
now,
if he should,
and if people went in and asked for a continuance, and then if they object, then you have to that'll quash your continuance you're asking for.
A good cause would be we are not properly prepared at this point. That I've heard mentioned several times when they ask for a continuance. And
yeah, but I would think you need something maybe a little more solid than just that, because it's okay. We don't mess around. You had so many days. You should have been prepared. I'd come in with a little better grounds than that.
Okay. What might be an example of it? Would be something feasible.
Well, it might be, say, that you don't have an attorney, you're doing this pro se, then the court might cut you a little more slack.
Uh-huh. Yeah.
Let's see, what else could you use? If you come up with a continuance and it's unopposed, then it gets granted. But if they would object, then it goes back to your grounds. You'd have to be showing that plaintiff is not being prejudiced. See what else. Yeah, plaintiff is not being prejudiced by a delay because they don't have any rights or standing on their claim to begin with, say something like that. And on the other hand, you are being prejudiced right now because you don't have enough time to prepare your case to your pro se litigants and you need more time. And really it needs to be a little better than that on your end.
Yeah. Well, one I'd state that one's standard rights would be... well,
here's where a good equitable maxim would come in.
Yeah. One's rights are being abused. If we should go ahead at this point.
Do you have any discovery in place?
Yes, we did put a request for discovery. However, we haven't received anything back.
I don't know if you could ask for something that would be pertinent to apply for this hearing that you would need from them that you hadn't received because they hadn't come up with it, and you could use that as a continuance ploy.
Yep.
Because they hadn't come up with the evidence yet, say.
Right.
They couldn't just hand it to you at court because that would be a surprise. You would have to have it at least, I think in bankruptcy, you have to have like 10 days prior to the hearing to be able to put a case together for defense or whatever it was.
Right.
But I would come up with something better than just, hey, we want a continuance, we're not ready yet.
Right.
You need a better show cause for a reason why.
Mm-hmm.
Then again, if it's unopposed, then it would be granted.
Well,
But nobody showed up on the board there, Matt, that was any good in bankruptcy or anything?
We do have one caller that hit star 8 north and central, what is that, Oregon? You've been unmuted.
Hi. Hi, CW?
Yes. Uh-huh.
Hello? Yeah, this is Rick at SoCal. I don't know where the gentleman is from, but I think, don't we have somebody that is in our group kind of that handles VK? His name's Carlos. So he's really, really good at VK, and he might be somebody as a resource that this gentleman could tap into.
Carlos is in California, and I believe you're in,
Arkansas.
Arkansas, yeah.
Yeah, but VK is federal, so most cases, most federal should transfer. But Carlos is really good. I forget what his Skype name. Maybe it's Trust Law or something of that nature. But perhaps Lisa could Skype the gentleman if he's on Skype. Maybe Lisa could Skype Carlos's Skype name to this gentleman, and then they could hook up that way. But I found Carlos to be very effective, and he's helped a number of people in our group in SoCal. Just thought I'd pass that on.
Okay. Appreciate it.
Yep.
Okay, anything else?
I was going to say, I don't think Carlos doesn't do bankruptcy with using NTT technology, does he? I think he's doing most of that on.
Do quite a few seminars on bankruptcy and things. He might be more wise on the process of, what bankruptcy is operating under.
Right. He might know how to get our pleadings in. Well, we'll give that a whirl. See what happens. Appreciate your assistance or your time.
Well, thanks for coming on.
Anybody else have a question? Hit star 8. Pretty quiet out there tonight, Christian.
Yeah.
Oh, here we go. Guest 18, you've been muted. Go ahead and give us your first name, please.
My name's Arnold.
All right, welcome to the call.
How you doing?
Oh, am I there?
Yes.
Yeah, I got some baby step questions, okay?
Sure. Uh-huh.
How do you fill out a UCC-1?
How to fill out a UCC-1?
Yes, sir. Steps for the what to fill in and what not to fill in.
Are you on the NTT, Welcome NTT group?
No, I'm under Patrick's group. I lost his file on the UCC.
I need to join in on the Welcome NTT Skype group and get in there because that'll get you access to all the stuff you really need.
What's it called?
Welcome NTT, Christian Walters. It's a Skype group. Do you have Skype?
Yes, sir.
Okay, Skype, Faith to Trust.
Phase 2?
Faith. F-A-I-T-H.
Phase?
Faith, and the number 2.
Okay.
Trust. Faith to
Stuff.
Trust.
Phase 2 trust or stuff? Couldn't hear that.
Trust. T-R-U-S-T.
Okay, yeah, it broke up a little bit. Trust? Okay.
F-A-I-T-H, the number 2, and Trust. T-R-U-S-T.
Okay. Now that NTT, is that different than the one you're on right now? There's Neomorpheus Community Call?
A central group that's Welcome to NTT, and that's a Skype group. And we're on there chatting and talking and sharing and passing information along.
And when are you on for that one?
24 hours, 7 days a week.
Oh, okay.
Worldwide.
Alrighty.
All over the world. People from Australia, Britain, Spain, you name it.
And what do you cover? Basically what I'm asking you?
Because they can tell you where to go on some of the back audios with specific dates. There's also transcripts that they can provide for you that goes over it and goes over everything that we're talked about in the past.
Okay, and how do you join the group, or how do you just get it, log on, or?
Skype Faith to Trust and ask to be joined into the group, and she'll bring you in.
Oh, okay. I appreciate it. Thank you very much.
Once you get in there, then you can get access to the transcripts and some of the examples and things.
Oh, okay. That'll be right. The UCC-1 and UCC-3 will be in there?
Yes. Now, we use the 1s and the 3s in a non-UCC fashion.
Okay.
And we use them as just as notices to past events. These are just public notices of things that have happened in the past that we've done, and these are not the mechanism that forms the trust. The UCC 1s and 3s are claims. These are not the mechanisms that claim and form a trust.
I see.
Just public notices.
I get it.
That seems to be a big misconception of what everybody thinks. That when you file the UCC 1s and 3s, that this is a mechanism that claims and forms the trust. No, it is not. It's just public notice of something in the past that formed the trust. But what the UCC 1s and 3s are is just records of what's been done and letting the public side know what we've done by notice.
Basically, let them know you know that there's a trust there?
Yeah, it's a colorful way of noticing them, but yet it doesn't give away the privateness of the formation of the trust and its details and its privateness.
I see. Well, sure. Thank you, sir.
Okay. Thank you.
I keep on listening in. I'll go to that Skype website.
It's not a website. It's just a Skype chat group.
Is that?
Virtual chat.
Oh, okay. Just like this one here?
Well, yeah, I guess you could call this virtual in a way. I guess so.
Yeah, I do Skype you only with a friend of mine, a guy named Archie. Have you heard of him? I don't know. But he didn't tell me that there was this, that you had a web or virtual chat there. Maybe he doesn't know.
Yeah, this one's on Skype, and what Skype's got, this one's on TalkShoe, and then TalkShoe has a website. But we just have a Skype group that everybody's on the Skype group, and then we have all the documents and thing on ForShare.
I'm sorry, broke up there. Could you repeat that?
We have the documents and things on ForShare, the audios and things.
Oh, okay. Right. I would look forward to doing that then.
But Skype, the Skype group will get you on the Welcome NTT, and that'll get you access to the ForShare, the documents, the printouts, whatever else, transcripts that we got.
Okay, and you got a kind of like a ledger on what to fill out on the UCC one to declare, like you say, just to show that we're not going, like you say, through declare the public side, but just to show it on log, or just to have a record of it?
Yeah, the ones and the threes are just notice of past events that has been done, that you've already claimed that there is a trust and you formed the trust. In other words, what you've done is you've done a withdrawal from the general deposit that you've already made, and you changed the nature and character of that general deposit and redeposited it as special, as a trust now.
Okay.
And these UCC 1s and 3s is just notices to the public that you've done that.
Okay. Yeah, I'm trying to learn all this stuff.
Not use a sequence of a 1, 3, and a 3, or whether you're going to just use a sequence of a 1 and a 3. A 1 and a 3 is just used for the formation of a trust. But if you've already made a general deposit and you have a general deposit already in existence, you need to change that general deposit nature to a special, and we do that with a 1, 3, and 3. Because the 1, 3, and 3 is actually pulling it out. The first 3 pulls it out, and the second 3 is going to redeposit it. Say, give notice of that you've done that.
Okay. Thank you very much. You have a good day.
All right.
All right, thanks for the question.
Nature and character of the relationship is the key, because the relation is being general to start out with, and being general, that's your whole problem, because general deposit automatically gives rise to the debtor-creditor relation, and that puts you on the at-law side in the court as the defendant and under the statutes and codes. So when you do a withdrawal from the general, pull it back out and change it back in as redeposit as special, now you've changed it from general to special. You went from the at-law side to the statutes, got out of statutes and codes. Now you're in under the private side, and it's under a private trust, which is the NTT side, under equity. And now you're in a different venue, a different court. You're in a different system. But the nature of the relationship is the key. It's the relation that's the key, whether you have a general relation or a special relation. I think that audio that we went over discussing the general versus special was like, what was it, 528 or 526 of 2010. But when you get on the Skype group, she'll give you the key audio downloads for specific ones, like the general versus special nature, the whole game plan from A to Z on what we're doing, and the repudiation, and there's different other audios that are key ones, and you'll get the list on that. Okay, anybody else?
That's it for tonight, Christian. I don't see anybody else who's got a question.
Okay.
So if you want to take an opportunity to say some closing comments, and then we'll wrap it up for the night.
Yeah, I'd like to stress that, check out those old equitable books from Google Books. Punch in there for Google search equity, and any of books that come up, like example Pomeroy or Snell or Loring or any of those authors there that are some of those old books. Check out the equity maxim sections where they give you the equitable maxims, and read those sections there that are discussing those so that you can understand what those maxims are. And then, because like I said, those are the shield, which is the defense, and that is the sword, that is the offense. And the shield and the sword, those are the equitable maxims. Read some of those old equitable maxim sections in those older books. That's what we're going to be focusing on here. I mean, I'd like to maybe put a break on this, what we're reading, and maybe Lewin or the CGSs I've been reading, and maybe discuss maybe some of this maxim stuff. Because if you get into a court of equity with the trust, equity's principles that it operates on are the maxims. That is the rules of the court that it operates on. And it does not operate just on form, process, and procedure, because that's what you're going to use to get into the court. But once you're into the court, now you've got to open door 1, which is at law, and say door number 2, which is in equity. And I want to get into door number 2 into equity. And then what do I do? How do I do it? And that's all on the equitable principles. So equities, where the private trust is, and that's NTT.
Outstanding. Well, Christian, thank you again for another great call tonight, folks. I'll plan on joining us next Wednesday night at 8 o'clock Eastern Time for another episode of NTT New Trust Technology. Until then, I am signing off. Christian, have a great evening, and we'll talk at you next week.
All right, everybody have a great week. See you Saturday.
All right, good night.